Welcome to Looking at Legal Stuff. Today we have part one of a story that covers two full cases, including an entire divorce case and then the ejectment hearings of the husband's squatter girlfriend. Part one covers 17 hearings with a very high conflict couple who are divorcing after 30 years of marriage. The husband will try every nasty trick in the book in an attempt to keep the marital home and all their other assets for himself and his felon girlfriend. This includes a protection order obtained under dubious circumstances, moving all of their money out of joint accounts, leaving the wife penniless, refusing to follow multiple court orders to pay spousal support and vacate the marital home, and when all else fails, he has his felon girlfriend squat in the house while claiming she has a lease that's actually fraudulent. His felon girlfriend also disrupts their divorce hearings on multiple occasions and gets told off by the judge, including an attempt in open court to record the hearing on her phone. In part two, the wife will have to go to court to have the squatter removed. What does the judge think of their antics? Let's find out.
Jackson and Jackson?
Yes, Your Honor, I'm here. This is Annette Jackson.
Ivan Culbertson on behalf of Elazar Jackson.
All right, and this was initially Ms. Jackson's motion, so ma'am, go ahead, go first.
Okay, Your Honor, I'm representing myself since I cannot afford a lawyer. I just, I don't even know where to start. My husband, I filed for divorce on the 7th of June after I was told he wanted a open marriage on the 2nd of May. And I discovered that he has been moving a lot of money around. His first financial declaration that he gave, or his lawyer gave, mentioned that he's making $7,000 a month, with me making $6,000 a month. I've turned in so far 2 financial declarations, which showing that I make about $2,300 a month. And he never mentioned in his income that he has actually Army retirement and disability, which brings his total to around $12,000 a month. So we're talking here about $10,000 more a month than I make. He made me move out on Sunday of the house. I've been staying in my car since then because I financially cannot afford a hotel. Besides, due to that, I had 3 back surgeries and another one coming up this year. I have to sleep either in a hospital bed or in a recliner. He had stated before that our oldest daughter had said that I could stay with her. That was falsely also. Her husband and her decided that he can stay with them. And he actually did stay with them for now nearly 2 weeks, and had mentioned last week in court he's still staying in the hotel, which was falsely also. He also, the restraining order that was against him, he came in the house, which I had proof of by pictures. He was not allowed to come in. I had returned this to the police department also. I don't want to burden my children any longer with the whole thing, since my daughter finally saw her husband after 1.5 years again from Iraq. And the short period of time that he was here, they had to deal just with their parents' divorce and the nastiness, and the grandchildren suffering under that. I have at the house, I have 2 Great Danes and 2 German Shepherds. He let me keep those right now at the house. Chances that I could rent a place are pretty none to nothing due to my income and due to the animals itself. I do have 7 reptiles too. He made me move them out of the residency before he took over on Sunday, which was not really, the commissioner had written in the restraining order that it will be by court, by the commissioner, said who can reside at the residence, and it never got said. It just got denied my restraining order against him. My animals are my everything for me. I will have another back surgery. I said that already, but I also have on August 1st, I have major dental surgery, which means everything is going to get pulled at that point. I have out of pocket for $3,800, which I had saved up that money to put aside. He's going on vacation next week with one of his, let's say, lady friends for her 40th birthday to Mexico, to the same place that we spent our 25th wedding anniversary, at the same hotel. So, I mean, this is a little bit very hard on me. Due to that, I had severe mental health incidents. I tried to commit. I was, I'm still in mental health classes 3 times a week. I can't work right now, not that much, due to my back injuries, due to my mental health, which is like an extreme roller coaster, and due to all my court appointments that I'm having right now. So we had, with my gross income of about $1,800 a month, and his income of about $12,252, we wanted that he keeps on paying the mortgage and the bills, just like we had it all the time. He was the main bread maker. I was just the one who supported a little bit here and there under it. And so I just wanted that I can move back into my residence, since I do need my animals extremely. He's going on vacation. Who's taking care of the animals? I'm staying in my car right now. So I'm requesting, after everything is taken off, all his thing, I'm requesting of spousal support of $2,177. He also took out of our joint account, opened up another account just in his name, been moving money in there. He's paid, let's say, all his lady friends, I don't want to say it any other way, since April, over $10,000 out of our joint account. Just in the less than 2 weeks, $3,200 to a lady that is in rehab, which I do not understand. But so this is what I'm requesting at this point, to be able to move back in my residence, to be with my animals, to enjoy my children again and my grandchildren, because they like to come over on the weekends. We are going to the lake and we're doing a lot of stuff, and I have not been able to do that. And I'm requesting spousal support.
Mr. Culbertson?
Yes, Your Honor. I'd like to note that my client filed an amended financial declaration yesterday, which acknowledges that he makes an additional $4,045 in combined military retirement and military disability, which brings the income to $11,885, along with his job. So what the opposing party doesn't mention is that she assaulted Mr. Jackson. She was arrested. After she got out, she went and sought a civil protection order where she didn't mention that she'd been arrested or that there was a divorce. So that was the case that was dismissed. And he wasn't even served with that. The way I found out about it is on a Friday, he met with me and he gave me paperwork, including the district court case, and where there was a restraining order against the opposing party. And somebody had handwritten in that, well, who will occupy the house will be dealt with in the civil protection order case, which was subsequently dismissed. So that protection order in district court still exists. She moved out on Sunday. He'll make all the payments. You know,
what does that protection order say, if anything, of the one that was granted? What does it say about the house or anything like that?
It said that'll be determined in case number, and then they had the civil protection order that was dismissed.
All right. So it has no other orders related to property.
No.
All right, thank you. Go ahead.
So in his proposal for temporary orders, yeah, he said he'd propose that he'd pay all the bills except for her auto insurance, but he can pay her auto insurance as well. They're on the same insurance plan. So there's going to be some kind of spousal support. I don't know anything about him going on a vacation. That's the first I've ever heard of that. But I know that he takes care of the animals. But, you know, the animals seem to be a big theme here. And it's not a big thing that she assaulted him and got arrested for that.
All right, ma'am, anything you want to add?
Yes, Your Honor. So the animals, the dogs are truly, honestly, are very afraid of him because of his temper that he tends to hit after him or yells at him. The restraining order was after he hit me and falsely stated something different to the police department. He hit me, he took my phone away from me, threw it on the floor, tried to break it because I have all the evidence on my phone from all his vacation trips, everything else. Like 2 days after he told me that he wanted an open marriage, he spent over $600 already at Victoria's Secret. He booked a hotel room for almost $400 at Seaside. All of those things. And I holded on to his t-shirt and he ran, and that's how his t-shirt got ripped. He is a retired military man. He has severely PTSD. I have always been scared of him. He used to beat our children that bad that CPS was involved at one point, and I had to hide our daughter from CPS. So the chances of me walking in a room and start hitting him are really low to nothing. At the end, yes, I not insulted him, but I hurt him because in my own defense, after he had hit me and I'm just trying to get my phone back. He then took with my phone, he ran off and locked himself in the bedroom. And that's why I got arrested. But that's a whole different case. It has nothing to do with the family law at all.
I agree. Let's move on from that.
Yeah. So I just want to go back in my house, be with my animals, and get child support. Not child support, spousal support. We've been married for 31 years.
All right, well, it sounds like the financials have gotten a little bit closer. And obviously there's some disagreement about the history. At this point, Mr. Jackson will remain in the family home. He's to maintain the house, take care of the animals. He's to provide her maintenance of $1,600 per month. And he's to maintain the vehicle insurance. If and when Ms. Jackson hires counsel in this case, he's to pay $3,000 towards her attorney's fees. But that'll only be upon proof that she's hired counsel.
Okay, so Your Honor, so for me right now, so with him even paying the mortgage and everything, I cannot go in my house.
Correct.
So it's okay for me to stay in the car with my back issues. And what is when he's going on vacation next week? Who's taking care of the animals?
Well, hopefully you will find some other place to live with the maintenance payment, and it's the animals are his responsibility. And counsel, okay. Ms. Jackson did submit a proposed order. I've made a number of changes in that to reflect the ruling, and the clerk's office should be able to email both sides a copy of that when we're done.
What does that mean, Your Honor?
You'll get a copy of the order that I just signed that reflects what I just told you.
Okay.
All right. Thank you.
Okay. Your Honor, one other thing. How do I communicate with Ms. Jackson?
At this point, do you have a phone number for her?
I have a phone number my client gave me.
Okay. Yeah, at this point, she's not represented, so you're free to contact her directly. Ms. Jackson, if you do hire counsel, you should notify Mr. Culbertson or have that attorney notify Mr. Culbertson immediately. Understand that?
So Your Honor, Mr. Culbertson doesn't even has an office. He only has a drop mailbox. We've been trying to serve him there. I couldn't even find an email. Calling him up will go directly to voicemail. So right there, I have a little bit an issue with that.
Okay, well, there's a phone and a fax number and an address on his pleadings. I suggest you use those.
Yes,
It's
Your
a-
Honor, I did, and it's not there.
It's an executive suite. She just has to call me. We'll set an appointment. We'll meet.
Well, Mr. Culbertson, we had sent 3
Okay.
people over there. We had
And-
3 times, 3 people
Yeah.
had called you up, and your phone
Ms.
went
Jackson?
directly to voicemail.
Miss Jackson,
Yes.
call him and make an appointment. Okay.
Okay.
Thank you. That'll
All
be
right.
it.
Thank you.
Annette Jackson, are you on the line today? Annette Jackson?
Yes, I am.
Okay, welcome to you, Ms. Jackson.
Good morning.
Good morning. And Eliezer Jackson, are you on the line? All right, and Mr. Jackson is represented by Ivan Culbertson. And it looks like as far as service on today's motion, which is a motion for contempt brought by Ms. Jackson related to a recently entered order of July 18th. Let me just pull that up here. So it looks like as far as service of the documents, Ms. Jackson served Mr. Jackson on August 6th with an order to go to court and a declaration of Ms. Jackson, a motion for contempt, and a proposed order and a note for hearing. And then since Mr. Jackson is represented by counsel, Mr. Culbertson as counsel, there was a mailing that was accomplished by Martin Hines, and that occurred on August 18th. And today, let's see, August 18th.
But that's for the next hearing already. That is scheduled for the 12th. That's when he got those papers. Those papers that Mr. Culbertson's received are for the next hearing for the 12th already.
Oh, the ones that Mr. Hines sent out via mail?
Yes. Yes.
Okay. And was there service upon Mr. Culbertson for today's documents?
No, only on Mr. Jackson. And I mean, you would assume that Mr. Jackson let him know all of that, but no.
Okay. Yeah, I think, one of the concerns is that when there's an attorney in place, that service goes to the attorney as opposed to the individual.
Okay, so, but I had emailed the attorney. I have not heard from his attorney. He has not responded to any phone calls, emails, text messages, or anything since July 20th.
That's you saying Mr. Culbertson has not?
Yeah.
Okay.
He has not. We had the discovery. He's not answering the phone. I've been setting up the appointment for the RC26. He's not responding to the phone calls. He's not returning the phone calls. He's not responding to any emails or anything.
Okay. So
I'm like completely in the loop right now. And I'm just hoping this is not going to go in another contingency, because this is what the 2 of them are doing the whole time to me. And it's just like Mr. Jackson is just blowing the money left and right, and he's selling stuff, and I have no access to my house or anything. He packed everything up for me. I have no clue what I have.
Okay. All right. Give me just one moment. I just need to refresh my memory on one of the rules here. Just one moment.
He hasn't given me my car, anything. He says to everything, he says just, well, I can't. I don't need to. He changed all the locks. My kids are asking him, Dad, why you did this? Because I can. I have no clues how my dogs are doing or anything. He moved his girlfriend in. He moved another woman in. So I assume he's getting rent paid. He sold the horse trailer, everything that he's not supposed to do. I live mostly out of my car. I have back surgery coming up again. So yeah, he makes enough money to rent an apartment or anything, so I would not have to live on the streets.
Yeah, I appreciate the input, Ms. Jackson. I'm still just looking up that
Yeah.
rule. I want to just briefly review. Okay, thanks for your patience, Ms. Jackson. I was looking under Civil Rule 5B.
Mhm.
Service and filing of pleadings. It reads service, how it's made. Subsection 1 says on attorney or party. It says whenever under these rules service is required, which it is, to be made upon a party represented by an attorney, the service shall be made upon the attorney unless service directly upon the party is ordered by the court. So that's what I wanted to double check. So it looks like there was the service that was made upon Mr. Jackson was made upon him directly. The rule requires that the service be made upon the attorney if the attorney is representing the individual. So here, I don't think we can move forward today without the service being made upon the attorney on this particular motion for contempt.
I mean, so even that I had told the attorney in writing that he's in contempt now and that I'm filing for contempt.
Yeah, the service requires all the relevant documents that were served directly upon Mr. Jackson. Those needed to be served upon Mr. Culbertson.
Okay, so the problem with Mr. Culbertson is we can't serve him. He has no. I mean, I emailed him last
via mail. This most recent mail.
Yeah, but yeah, prior to that, we were not able to serve him at all, and so I even sent him an email last week asking him if I'd be able to serve him prior email. He still has not responded to that either.
Right.
He has not responded to the mail that we sent him either.
Right.
So, yeah, I'm like, English is my second language, and I'm getting this here together by myself, and yeah.
Yeah, and I appreciate the fact that you're providing courtesy communication via email and the like, but the rule requires under 5B1 that if a person's represented or has an attorney, then the service of the documents that we're going to be talking about today has to be made upon the attorney. So if you'd like to reserve those documents, then you could note it up for a future hearing, and we can address these important issues that you've raised in your contempt.
So if I get him served this week and I have on the 12th, the other hearing, will that get entered into that?
Well, you can check online and look under Calais County Local Rule 88. That gives kind of the timeframes that you need to look at in setting hearings. So I'd encourage you to look at Civil Rule 88 under the Calais County Superior Court website. It has a nice listing there of the.
Yeah, and I know it's 3 weeks always in advance. So that's why I had set it up like 2 weeks already, the hearing for the 12th. So that's why I was wondering if, since, I mean, they both know that it's coming or that it's there, Mr. Culbertson and Mr. Jackson, if we can just, like, if I serve Mr. Culbertson probably by email, because he won't accept anything else, that we can bring this issue up on the 12th for the hearing too, which is another contempt.
Well, there's usually process of service is interpreted or analyzed in fairly strict manner. If another party agrees to have it heard at a different time, there's no issue with that, but the party has to agree. So I just encourage you to look at the rule, local rule 88, as far as the computation of time. And then if you are able to communicate with the other attorney or the attorney and he says that he agrees to that, then we could potentially hear it on that date. Otherwise, you just need to follow the rule 88 and setting the hearing.
Okay.
All right. So I encourage you to do that if you want to have the motion heard, which it sounds like you do, and then we can hear it and address the issues that you've raised. All All right, next, let's move to the Annette Jackson and Eleazar Jackson matter. That's cause number 23-3-24408. Here, I see that Ms. Annette Jackson is on the line. Ms. Jackson, can you hear me okay?
Yes, I can.
Okay, welcome to you. And then I also, Mr. Culbertson, are you on the line? So Mr. Culbertson represents Mr. Eleazar Jackson. So I'll ask if Mr. Eleazar Jackson is on the line. Okay, I'm not hearing any response there. Ms. Jackson, have you had any communication with Mr. Culbertson, the attorney for Mr. Jackson?
I've been emailing him, calling him, texting him. The last time I heard from him was July 20th. He's not replying to anything. We've been sending him the serving papers. I've been contacting him about the discovery of his client. I've been contacting him about my discovery that I sent him. Nothing. I'm getting nowhere. And also, Mr. Jackson, of course, is not replying to anything from me either.
So when we were here last, Ms. Jackson, back on
Yeah.
August 29th, we talked about service and how to serve folks.
Yeah.
And so it looks like
I did all of it.
Since that date, we talked about serving the attorney as opposed to the person. So it's like
I did that.
Mr. Cooper Lucas personally served Mr. Eleazar Jackson and did not serve the attorney.
So that on Mr. Cooper, that was just the other day, and that was for the hearing on the 26th of September coming up.
Oh, okay. All right. So
I had on the 17th, I think, of August, served Mr. Culbertson's by email and by mail.
okay.
Because you cannot, he doesn't really have an office. He just has a mail slot. You have to break into that building. Not even on his website is the right zip code written on it or anything.
Okay, thank you, Ms. Jackson. So I see on August 22nd, there was filed a proof of mailing that on August 18th of 2023, let's see one moment, that Martin Hines caused to be mailed in the U.S. Post Office Service documents to an address in Vancouver. And that address in Vancouver, where did you obtain that address?
Of his website.
Okay.
And of the cards, his business card that he has given me and everything else prior to it. And that is written on all the court orders too.
Okay. Let me just check one item. I'm just gonna just pull up the Washington State Bar Association website and just verify that address.
It is the address because I had him served personally there before too.
I'm just checking for my own sake.
They had to drive in.
Okay, that matches with what I see on the Bar Association, the address that's in the August 22nd mailing.
Yeah.
So, and then just to verify, Ms. Jackson, have you received any communication from Mr. Culbertson in response to the motion for a temporary family law order?
No.
Okay. All right, so then your requests are your request for an increase of spousal support from $1,600 a month to $3,000 per month, and then you're wanting a housing deposit or assistance for first and last and deposit of $5,000. You're wanting an accounting of funds and also money to be deposited into the court registry.
Yes, because I mean, if you look at the attached paperwork that I had sent it, how much money he had blown in the last 2 months, over $108,000. He has moved around, but he's saying he has no money. I'm living literally out on the street at this point. I'm very sick. I have to have another back surgery, and he denies me everything. He even denies me entrance to the house to get my personal belongings out or anything. He moved in with his girlfriend. They
Ms. Jackson,
packed.
Ms. Jackson, I appreciate you rehearsing the things that I've
Yeah, I
previously
know.
read in
I
your
know.
motion. So I've read
I'm
all of
sorry.
that. I'm familiar. No, you're fine. Just want to make sure that you knew that I'd read all of your pleadings and was
Okay.
familiar with that. So you had also made an indication that on paragraph 9 in the July 18th order that there is a mismarking.
Yeah.
That should not have said no request made, that should be removed because it shows that the parties are obligated to make a payment as ordered below that.
Yeah. And I had given that notice to Mr. Culbertson's also in writing and in talking on our last meeting on July 20th.
Okay. Bear with me just one moment.
But he never replied to it. I sent it in an email to him.
The one question I have for you, Ms. Jackson, is from July 18th until now, you're seeking an increase of spousal support from 1,600 to 3,000 per month. What has been the change in your circumstances or his circumstances from then until now?
Well, circumstances are that I'm still homeless. I cannot get any place to live because of my income. Everything has to be 3 times the amount. I have been, all those years for 31 years taking care of everything. I don't have the income. My credit score, which he had put in a financial declaration, he written in that he's paying for 1 credit card that he has, that it's in my name, but I never had it. He stopped paying on it. So my credit score dropped down by 100 points. I can get nothing.
And
so that's why I had
the credit score has dropped from
760
July.
to,
I don't need to know the score.
no, yeah,
But it's changed from July 18th until present by that amount?
from June till present,
Okay.
from the moment I've turned in the paperwork for the divorce.
So then help me understand exactly. So then the changes that you're saying that have occurred since July 8th until the present
Yeah.
are that there's a problem in getting a rental because of your income.
Yes, of my income.
Is that a
And
change? Is that a change, or is that a pre-existing did that exist prior to July 18th?
that was prior to July 18th already. It's like he has, I know it's not important for the court. For me, it's important. He has all my dogs that are suffering right now extremely because they're getting abused. And I cannot find a place where I can take my dogs with me. And I mean, the rental situations out there right now. I'm looking at an apartment with 600 square feet for $1,900.
So I guess that's my question. In order for there to be a modification of a court order, this is not too long ago, July 18th, there needs to be a change in circumstances of the parties. And from what you're telling me is that the rental situation has been bad prior to July 18th, and that same economic situation existed then as it does now, or prior to the July 18th order. So
Yes.
that's my basis. In order to change it, I need to make a finding of adequate cause, that there's enough there, there's been enough of a change to allow that court order to be changed, because there's this general sense that we want to have court orders stay, and we don't want them to be changing every other week, and we want some continuity and some certainty.
At that point, I had asked also for the house back, because I need to live in the house because there's my medical equipment for me in it that I cannot move around for my back. I'm looking at another back surgery also. Since I did not receive the house back at this point, I have to start looking for other options. Housing market is tough. I didn't look at that point on July 18th at getting an apartment or renting a house or anything, because it was my hopeful understanding that I get the house back. He does need it. He works down in Portland. He makes 5 times the amount of money that I make, he can get easily an apartment right next to his work. I can't.
Okay.
And that's why I had also asked in the paperwork that he has to co-sign for a place, because
Okay.
I will not be able to get anything.
Okay. So I'm granting your motion in total. You served properly and there hasn't been a response. And so I would encourage you for next week, I need you to prepare an order that grants everything that you've requested here today, and we'll put that on for next week's docket. You'll need to send a copy of that to the court so I can review that before the docket. And then I can sign off on that date.
For next week or for the 26th?
My apologies. The court clerk reminded me we're not here next week on the 19th, but we are here on the 26th.
But that is for the contempt, because he's also in contempt and he's not doing anything. I still do not have, in the 18th of July hearing, he's supposed to give me back the other car. He hasn't done that either. He's been selling.
So we'll hear that on your contempt motion on the 26th. What I'm saying is that, well, I'm granting what you've requested for today's hearing. You requested that in an increase in spousal support, you asked for housing assistance of $5,000. You asked for an accounting. You asked for money to be deposited in the court registry. There's been no opposition filed to that. You did file that. So I need you to prepare an order that grants everything that you've requested in today's hearing that was slated for today. You're going to submit that to the court so I can look over it, make sure it looks proper, and we'll be here on the 26th for me to review and sign that, in addition to the contempt hearing.
Okay, so
That makes sense?
yeah. Are you going to send me this in an order? Can I pick this up somehow, what you all requested today? Because it's very.
I made no requests today. I'm granting what you requested. So therefore, if somebody wants something, the general rule is that you as the moving party, if you win, then you prepare the order that says, hey, this is what the judge ordered and this is what I get. So I'm asking you to prepare that order as the litigant, just as if you were an attorney, to prepare an order that says that you get everything that you asked for in today's motion.
Okay.
So then you'll prepare that, you'll send a copy to the court in preparation for that. I'll review it, and then we'll be here on the 26th to review it together. And then we'll go from there.
Okay. All right. Thank you, Your Honor.
Okay. We'll see you then.
All right.
Thank you.
See you then. Bye.
Bye.
Starting early, and I'm still letting people in the Zoom hearing room. But I do see one of my cases has both parties present. Ms. Jackson, oh, you're connecting to audio. Mr. Jackson, can you unmute? And Ms. Annette Jackson, can you unmute? Ms. Jackson, you're still muted.
Okay. You hear me now, Your Honor?
Yes, I can. Thank you.
Thank you.
Mr. Eliezer Jackson.
Yes.
Okay. Sir, are you, where are you zooming in from?
Hospital.
Okay. Are you currently under medical care?
Yes.
Okay. It's typically not my preference when someone is in the hospital under doctor's supervision to have you go forward with the hearing. Are you in a medical state that you feel like you can go forward with this hearing today?
Yes.
You do? Okay. Do you know when you'll be home from the hospital?
No, not at this point.
Okay, please, everyone online, please silence your phones. Okay, well, we're going to do what we can, but I just want to say, Mr. Jackson, it wouldn't be my preference to proceed this way, but if you want to proceed, we will. The cause number here is 233-0024408. I will just state initially, Ms. Jackson and Mr. Jackson, you may recall, I was the commissioner on the civil protection order docket.
Yes.
And so, because I did make a ruling that was opposed to one of you, I want to make sure you both are aware that that was me. I have seen that that document is filed in this case. And so is anyone asking for a different commissioner or judge to hear your family law matter?
I mean, I would prefer Judge Evans again.
No,
Okay, so I can't promise you a specific judge. My request is, do you believe that, or are you requesting that I recuse from this case? Is there something where you believe that I would not be able to be fair and impartial because I did deny a request from one of the parties for a protection order that seems to relate to some of the facts going on here?
No, Your Honor, it's just that other fact that is going on is not till the next hearing till November 1st. So this, what about the civil matters has nothing to do at this point at 2 days. It's all
Okay.
about contempt.
Okay, I just wanted to make sure everyone was comfortable. I feel I can be fair and impartial, but I just want to make sure both parties are in agreement with me on that. We want to make sure everyone gets a fair shake in this court. The other thing I want to point out, couple housekeeping matters, because Mr. Jackson was previously represented, as Ms. Jackson noted, you previously were pre-assigned to Judge Evans' docket. He holds that docket for people who have attorneys. When your attorney withdraws, then you get bumped onto a Wednesday docket where you are, because you are unrepresented. So that's why you both have changed dockets that you are used to. And I did note that Judge Evans held a fairly lengthy hearing when you all were in front of him on September 12th and made some rulings that ultimately resulted in a temporary family law order that was signed. Are both of you aware of that?
Yes, I am, Your Honor.
Okay. So I'm also going to point out that just yesterday, I received from Mr. Jackson a series of lengthy filings regarding this case, including some requests to vacate prior orders. I think that, well, they're not scanned into the system yet, so I don't have them in front of me now, but I did look through the whole stack yesterday. Have those been served on Ms. Jackson yet?
I truly, honestly do not know, Your Honor, because I haven't received anything in person of, they have been putting servings paper on my daughter's car in the middle of the night in the rain. I do not know no more when I get served, what it is. I got emails. I asked what this is. I'm not getting, the only response I get being harassed. So, and I thought those would be for November 1st hearing that they asked for.
And I'm just, and I'll do the scheduling of when we're hearing what, but I'm just making sure and trying to ascertain who has what paperwork, because there is a lot.
Yeah.
So it sounds like, Ms. Jackson, you don't yet have the stack of Mr. Jackson's motions to the court.
If they got filed yesterday, no.
Okay. So then my next question is, I was just this morning handed proof of service from Vanessa Jackson on Mr. Jackson. And it states that these documents were served on him October 11, 2023, but it does not list what documents were served on him that date. It left that part blank. Do you know?
It was, I mailed it. We had it to mail, and I do not know right now what it was in my head. I really.
Mr. Jackson, do you know what you got on October 11th?
yes,
What was it?
I have to look it up, but I
Okay,
did get it. And I do have proof of mailing proof of service posted that she was served properly.
okay. Well, we're not moving forward on any of your motions today. There wouldn't have been timely citing in on this docket or timely service anyway, but so we will deal with that on a different day.
Okay.
So did you receive Ms. Jackson's contempt motion? And in this most recent contempt motion, and what is actually on my docket for today, is a request for payment for me to find contempt in the amount of $66,000 and some change. Have you received that?
Received it, but I don't know where she's getting those numbers from.
Well, and we'll talk about that, but I just want to make sure you've had a chance to look through that.
Yes,
Okay.
and I provided proof to the courts already on that.
Okay. So Ms. Jackson, in going to your motion, there's a lot of moving parts here, but my understanding is the thing that is in front of me today is your most recently filed motion for contempt.
Yes.
And in that motion, you state that the respondent has paid you a total of $3,200 in spousal support since Judge Evans signed his temporary order. However, it sounds like you're coming up with this number because of the allegations of transferring money and withdrawing cash.
Yes.
Okay. So I'm going back to the
Time he had paid me $4,800. I just want to, on spousal support.
say
And
that again.
it wasn't October yet, so it is by now $4,800. He had paid me.
Well, that may be, but what I have in front of me is an indication for this motion today.
Yes.
And I can already tell y'all are going to see me many times over the next few months. So we have time to deal with all the issues, but what's in front of me today is your motion. And it looks like the $3,200 in spousal support from the temporary law order has been paid. So we can kind of take that off the table for this motion.
Okay.
What happens with future unpaid spousal support can be addressed at a future date.
Okay.
But I'm just trying to ascertain, it really appears as if your contempt is this $66,000 figure due to transfer of money.
Mm-hmm.
And I'm reading through the temporary order. Well, let me turn it. Let me stop talking. Let me turn it over to you. Give me the basis, if you will, of your belief that he is in contempt of a court order whereby he owes you $66,000.
Well, so he has not turned in his discovery yet. He has took out loans in over. I have that all filed with you too. I don't know who this is on my screen right now. I have somebody on the screen. Somebody blinked in there, Your Honor.
Say that again.
No, there was somebody with purple hair in my. Somebody had checked in the video. So I couldn't see you. I'm sorry.
Okay.
So I have. He has not turned in any of the discoveries or anything else yet. I have no credit report, nothing, and he has been. And his financial declaration is not up to date. He has cash deposited last year 97,000 and something. He took the loan out with 38,000. He took another loan out with 38,000, with 26,000. He has he transferred in his USAA savings account 12,000. He has another loan with upgrade with 5,000.
Okay, well, and that's, so let me just stop you there.
Yes.
I'm gonna turn to Mr. Jackson. So Ms. Jackson, I'll say this, some of your concerns might be better part of discovery requests or motions to compel discovery. But I want to turn to Mr. Jackson, excuse me, and go through what the temporary order actually ordered, and let's see what you've done and what you haven't done.
Okay,
So I'm just going to read it from the judge's ruling on September 12th. So first, you were ordered, Mr. Jackson, to provide a credit report to the petitioner to verify any other accounts you have opened in your name within 24 hours from the time, that you have opened in your name, and you're supposed to provide that within 24 hours from the time the order was entered. So have you at any point since September 12th given a credit report to Ms. Jackson?
I have never seen that order, so no.
That order was served.
Oh, ma'am, hold on. Just ma'am, it's my turn to talk to him. I will come back to you. Were you here on the September 12th hearing?
No. September 12th was supposed to be a deadline to turn in paperwork. And before I could get the paperwork in, I guess.
Oh, you had an attorney present at that time.
No,
Yes, Mr. Culbertson was still representing you on that date.
he didn't show up to court for as I know, and he never gave me any paperwork, never said anything to me.
Okay, so you have not seen, have you seen the September 12th order?
No,
Okay. So you haven't supplied a credit report, correct?
no,
Okay. Is that something that you can do?
sure,
When can
Yeah.
you get that done by?
probably today. It's not hard.
Well,
Her
I'm
name is on my credit, so I don't know why she can't get it herself.
sir, because she's not going to pull your credit report. So I can find you in contempt today, or I can give you another 24 hours. What would be your preference?
24 hours. I don't know.
Okay.
Like I said, I don't know anything about that order.
Okay. Then you were also ordered to trade vehicles with the petitioner. Have you done that?
No,
Okay. Ma'am, are you still asking that the vehicle be traded with you?
Yes, because it was already put in on July 18th in the orders. Every single time it was put in the orders to trade the car.
Okay. Sir, when can you get that done by?
so I'm supposed to trade my car that's in my name to her.
The order states that the petitioner will use and possess the 450 GL Mercedes-Benz. And then respondent will possess and use the 240 Mercedes-Benz.
So I provided the court documents that is my vehicle, not hers,
Okay.
and she
Well,
is driving her vehicle.
So, sir, I'm just letting you know what a prior judge has already ruled during a period of time when you were represented by counsel. So I don't want new argument on it. I just want to know when you can do that. When can you make that transfer?
As soon as I get out of the hospital?
And do you know when that will be?
No, not yet.
So like today or a week from now?
It could be a week. I just got here last night.
Okay. On that one, what I'm going to do, especially because you are in the hospital, I also have seen the paperwork you filed where there's some allegations of issues with your prior attorney that are probably going to turn into a bigger issue. I'm going to have you all come back next week on this Wednesday docket at 10:30 a.m. We're not done going over the contempt motion, but I'm going in my new review order. You're going to have until next Wednesday at 10:30 a.m. to make that car transfer. Otherwise, we're going to readdress it next week, okay?
Okay,
Then there's a couple more to go through. You were ordered to disclose that same day, September 12th, where you had hidden the money from your bank accounts.
getting what money?
I'm just reading what the order says.
I don't,
Okay. That is something we'll review on 10:30. And I think in reading the judge's notes from Judge Evans' hearing was essentially that if there are bank accounts during your marital time together that have shared funds that Ms. Jackson doesn't know about, she needs to be told about them. Okay.
there's no shared funds, there's no bank account that you don't know about. No, I don't have any bank
Well,
accounts you don't know.
I'm going to keep that in the order for now because you all are still in the discovery process. There was another requirement that you deposit the money that you had taken from the joint Chase account and deposit it into the court registry. Essentially, that means it's for safekeeping pending the court deciding how to divide it up. Have you done that?
What money?
The money from your joint Chase account.
That she took. I didn't take it.
Okay. This is what Judge Evans ruled last week. I'm going to keep it in the order. I'm going to give you until next week to deposit, and I'm just reading from the order. Deposit the money he has taken from the joint Chase account into the court registry. Okay.
Okay.
And
I
then
have to deposit money that she's taken? I'm
no,
need to
that you
understand.
have taken, that you
What
have
money have
taken.
I taken? That's what I'm trying to understand.
Sir, this is not, I'm reading you what the judge ruled at a time when you were represented by an attorney. So then the last thing the judge ordered was that you were to give $5,000 towards renting a place to live and co-sign if necessary, if you're to remain in the family home. And Ms.
Say
Jackson,
again?
Ms. Jackson, I may need some clarification on that one. I'm not quite following what the judge's ruling is on that.
Yeah. Am I allowed to speak, Your Honor?
Yes.
So the judge had, at one point there was about the $5,000 in co-signing, but he also signed on the 12th of September that I can have back our residence and he has to move out because prior to that, it was already that he has to move out with police standby. That was on the 12th of September. He put that order in that he need to move out with police standby. And
Okay.
it should say in the order too.
I did see that. And is he moved out?
No,
Okay, so you were supposed to have moved out by September 1st, or if the order was signed later at a later date. And I think the order was entered September 12th. So you were supposed to have left the residence with police standby if needed by September 12th.
You know that if you never received the order.
How am I supposed to know? I've never seen no order saying that, so I don't know.
Your attorney is under.
Okay.
The SB investigator.
Where can you be served right now, sir, if Ms. Jackson is to get you a copy of this order?
I'm in the hospital. Legacy manual.
Okay, sir, where can you be served? Where do you have an email address she could send these documents to?
She knows my email address, yes.
Sir? Okay.
Give her.
Sir, I am simply asking questions. I don't need defensiveness. I just need to find out if you have an email address. So
Yes.
the response isn't, she knows my email address. The response is, yes, I have an email
Yes,
address.
I have an
Or no,
email.
I do not have an email address. Okay, Ms. Jackson, do you know his email address?
yes, Your Honor.
Okay.
And he had those
They
papers.
made the decision.
So hold on. There's a lot of talking with both of your backgrounds. what I'm going to do today, because it sounds like Mr. Jackson is very confused. It sounds like this order was entered by Judge Evans on September 12th following a hearing on the merits where Mr. Jackson was represented. It sounds like that may be an issue between Mr. Jackson and his
That order
attorney.
came out.
But out of an abundance of caution and equity, I'm going to hold off on ruling on the contempt. Ms. Jackson, I'm going to have you email or a third party. Could your third party who served him email him instead, Vanessa?
Yes.
Okay.
Yes, of course.
Please have Vanessa email him the September 12th order from the judge.
Okay.
We are going to come back in 1 week. Do that today. We're going to come back in 1 week. So next Wednesday, is that docket still open? It should be. Okay. So next Wednesday at 10:30, same Zoom link. And we're going to revisit the contempt motion. But I also, Mr. Jackson, am going to review for compliance with these conditions. I will take into account that you have filed a motion that seeks to vacate some of these orders. And we can talk about that next week as well, because those are not in the court system yet. Okay, does everyone know what we're doing next week?
Yes.
Yes.
Okay. And Ms. Jackson, what I'm going to do with your motion right now is just reserve ruling to next week after Mr. Jackson can receive and review the order.
Okay.
Okay.
I'm gonna go ahead and provide all of
Okay.
that, every single.
Your Honor,
Yes.
can we please have not somebody telling him the whole time what, it's very disturbing to hearing another voice in the background telling him what to do. I don't.
Yeah. All I can say, I guess, to all parties who are on this docket, when you come before me, I expect that it's the parties that are addressing me, and you're not being, fed information from someone else in the room. Much like if you were here in the courtroom, I wouldn't be allowing someone to be whispering in your ear as you're responding to me. So that's just a blanket statement for everyone. I know Zoom courtrooms feel much more informal, but they really are still courtrooms, and we expect the same kind of behavior and decorum. Okay.
Thank you, Your Honor.
Thank you both. I'm going to see you both back here 10:30 next Wednesday. Okay.
Okay. Thank you so much, Your Honor.
Thank you. Do I have Annette Jackson present?
Yes, you have, Your Honor. Good morning.
Okay. So this is 233-002-4408. I have Annette Jackson and I have Eliezer Jackson.
Yes, Your Honor.
Yes.
And Mr. Jackson, are you still in the hospital?
I'm back in the hospital. Yes, Your Honor.
You are back in the hospital? Okay. Well, I hope that you're hanging in there. What is your request of the court today?
2 weeks extension.
Okay. Ms. Jackson, I did get your responsive documents to the motion to vacate. I have that matter to be heard on November 1st.
Yeah.
So my proposal anyway, regardless of Mr. Jackson's motion, because today we're just on for a review hearing on the contempt, because the contempt is so tied to whether we vacate the underlying order or not, I think we should consolidate all of these matters and hear it together on November 1.
Okay.
Are you okay with that?
Well, not really, but what are my choices? I mean, he has been having enough time. Every time we had a hearing, he got served. His attorney got served. He was aware of all of those. I had even reached out several times to him and said, hey, does your attorney still works for you?
Yeah.
And none of this stuff has been gotten done. And now my biggest concern, what happened now is I came home last night to my daughter's house because she needed me for babysitting.
Okay.
And I find out that one of my Great Danes had died. He was only 5 years old.
So I just heard a laugh online.
Yeah, that would be his girlfriend, Elisa Mr. Jackson's girlfriend.
Okay,
And
so
so-
I'm just, hold on one second, Miss Jackson. I'm gonna just ask, hold on. I'm gonna ask that everyone remain 100% respectful through these proceedings. Ms. Jackson, go ahead. I apologize for that interruption.
So one of my Great Danes, apparently he just died in his sleep. He's 5 years old. Doctors don't die in his sleep at that age. If he was sick, why was there not taken care of? He has refused me to see my dogs. He has refused to let me get into the house to see my dogs or anything of that. And all of this, so the dog dies, and a few hours later, his girlfriend files for a restraining order against me. Knowing that, you know, I'm concerned. There's 3 more dogs in the house. I'm just like, I really want to get back in my house. I'm like couch surfing since July. They have been purchasing my house. They have been selling items from me. They have been packing stuff up. I had asked where my stuff is. Nothing got done.
Yeah, I understand. And here's going to be my ruling. And Mr. Jackson, I don't need your girlfriend on the camera. She is not a party to this case. No, thank you. Okay. Ms. Jackson, she may have her own case with Ms. Jackson, but that is not in family law court. It's the 2 of you.
I know.
So I know, you know, Ms. Jackson. I am going to consolidate the contempt issues with Mr. Jackson's motion to vacate, have both issues heard on November 1st as already scheduled. Did I get that date right? Okay, thank you.
Yes.
So we'll have you all back. I'm not likely to grant any further continuances, Mr. Jackson. We have given you ample opportunity to be ready. So I am going to move forward. The order that we will do the hearing on November 1st is I will hear Mr. Jackson's motion to vacate and Ms. Jackson's response to the motion to vacate first. You can have brief argument time on that. I will make a ruling, and then depending on my ruling with that, we'll move on to the contempt issues if I keep the underlying order intact. If I don't, then we're essentially starting from ground zero and we would not be having a contempt hearing. So just want to make sure, Mr. Jackson, you know that absent some unforeseen emergencies, we are not going to grant any further continuances beyond November 1st. Okay. Okay. All right. Anything else for the parties?
I just have one more question, Your Honor. So when we have this next week, this hearing, does this include that contempt that we had to move from last week to this week over?
Yes, I'm consolidating the contempt into the motion to vacate date because I need to decide the vacate motion before I get to the contempt motion. So we're going to go ahead and put them all together. So yes, the original review that was on for today on contempt will now be next week, November 1st.
Okay.
Okay.
All right.
All right. Thank you both. You're free to log out.
Thank you so much, Your Honor. Have a good day.
You too. Mr.
Thank
Jackson.
you, Your Honor.
Yep, you're welcome. You're free to log out. I haven't seen Desiree logged in yet. Mr. Kamba, have you had any contact with Desiree?
Not at all.
Okay. Okay, so we're getting a lot of people joining this hearing in the last few minutes. If you're logged in as published writer, can you please tell me your name and what case you're here for? Okay, if you're logged in as Tanya Quinata, please tell me what case you are here for.
Elazar Jackson, Jackson versus Jackson. I'm just an observer.
Okay, and where are you observing from?
I'm observing from Cowlitz County.
Meaning, are you with an organization?
Yes, I am. I am a liaison for Washington Defenders Association for Northwest Justice Project.
Okay.
IMAP. and several other coalitions, NAACP and Black Lives Matter.
And do you plan on, I'm trying to figure out, we've had a lot of people log in for Mr. Jackson in the last few minutes. Is someone representing, is Mr. Jackson represented for this proceeding?
We are just observing at this time.
Okay. Someone is logged in as published writer. Can you please let me know your name? Okay. You are logged in as published writer. The court cannot hear you. Please let me know what case you are here for. Okay. Mr. Kamba, we're going to come back to your case. Okay. I think that leaves us with a case, Annette Jackson and Mr. Eliezer Jackson, 233-0024408. Do I have both of you back and present?
Yes, you have, Your Honor. It leaves me Annette Jackson.
Okay.
Your Honor, I'm here.
Okay. So help me understand, we have quite a few observers right now for this, and they're asking me questions about whether this is being recorded for the records of court. And I don't know what that means. So if you could help me understand what you are asking, I can respond. Are we all being recorded for our record? I still am not quite following the question, except to tell you that this is a docket that does have a court reporter, or excuse me, a court clerk. They are taking minutes. We also do record the live audio in the courtroom. It is available at a party's request to the Superior Court clerk. We also live stream these proceedings on YouTube as part of our open courts policy. Can I get a disclosure for this public record? I don't know what you are asking. If you are requesting a recording of this proceeding, you can do that through the Superior Court Clerk's office. So let me start with this. Mr. Jackson, let me just ask you, because you have several people who are indicating they are here observing on your behalf, on behalf of different and various organizations. Are you currently represented by an attorney in this matter?
No, Your Honor, I am not.
Okay. Are you proceeding on your own today?
I would like to get it set aside due to that I am very ignorant to the law, so I can get an attorney.
So you said set aside. Do you mean, are you asking for a continuance so that you can speak to an attorney?
Yes, ma'am.
Okay, because you have filed a motion to set aside a judgment that was previously entered against you when I believe you did have attorney representation. Does that sound correct to you?
Well, I didn't have attorney because he did not show up to court.
Well, okay. So what, and there's a long history with your case, which is fair to say, correct?
Yes.
And when I look back at that history, certainly dockets that I was not a judicial officer on, I do see that you had an attorney who, you know, whether you felt he represented you or not, did indicate to the court that he represented you. Is that fair to say?
That is fair.
Okay. And in reviewing your motion to vacate the judgment that was entered against you, that has formed the basis for Ms. Jackson's contempt motions, I do see that you're indicating one of your indications is irregularities in how you were represented by that attorney and what that attorney may or may not have told you about, informed you about, those sorts of things. Is that fair to say?
That is correct.
Okay. So then subsequent, and I'm just stating the history on the record so that if I am mistaken on anything, either party can jump in and tell me I am wrong. But what I also see is following that judgment and then Ms. Jackson's contempt motions and motions, I think both of you have filed motions to restrict abusive litigation.
I have not, Your Honor. I didn't.
Say that again.
I didn't file no litigation. That was their case. They started it. I did. I did a motion to vacate. The response on my motion, a response to the motion from them.
Okay. So you're not asking for an order restricting abusive litigation. You're responding only to his request.
That's correct, Your Honor.
Okay. Thank you for that clarification. So going back to kind of my original train of thought, after Mr. Jackson, you started to believe you weren't being adequately represented by an attorney, and you claim that you recently came to find out that there was this judgment entered against you, then you have now filed for the motion to vacate that judgment alleging irregularities in the proceedings and other things. Is that fair to say?
Yes.
Okay. And then we have been here on prior dockets wherein Ms. Jackson's motions for contempt based on Mr. Jackson's failure to adhere to the judgment were heard before this court. We actually continued those to first hear your motion to vacate. Is everyone on the same page with me on that?
I think so, yeah. Yeah.
Yes.
Okay. And because obviously, if we vacate the judgment in order, then there's no grounds for contempt. But if we don't vacate the judgment in order, then we move forward on the contempt motions for Ms. Jackson. Is everyone still with me?
Yes.
Okay.
Yeah.
And Your Honor, the way how I saw it, they were trying to vacate the order from July 18th and from the beginning of August. So, this has been almost 4 months now. And so, yeah, I'm just like a little bit confused why they want to vacate that, because they haven't really done any of those things either that was requested by the court.
Correct. And I think the allegation at this point, ma'am, is that Mr. Jackson is alleging certain irregularities in the proceedings that he believes the civil rules would allow this court to consider vacating the prior orders. So what I'm hearing today, Mr. Jackson, is your request for a continuance of today's proceeding so that you can seek counsel to be represented in this motion to vacate. Is that correct?
Yes, ma'am.
Okay. How much time are you asking for to seek an attorney for that reason?
3 weeks. I just returned back to work, so I gotta make time again.
And I do understand that you previously had some health issues that probably took your ability to seek counsel quickly away.
That is correct.
Okay.
Your Honor.
Hold on, I'll come to you in a second, Ms. Jackson. Mr. Jackson, just for purposes of deciding on your motion for continuance, do you have an appointment set up with an attorney currently, or are you still working on getting an appointment?
I'm still working on an appointment. I talked to one this morning.
Okay. Okay. Ms. Jackson, let me go to you. Mr. Jackson is requesting a 3-week continuance for purposes of being represented by an attorney in his motion to vacate. What is your opinion or your position on that? Are you in agreement or are you objecting?
So I'm objecting. So right now, my question is, Your Honor, with the
Well, hold
vacate.
on. Hold on, ma'am. I'm not answering your question. I'm asking you a question first. We will get to
No,
time
I'm
for
not.
questions.
I'm not okay with it.
Okay, so you are objecting to a 3-week continuance. Can you tell the court why?
Because he kept on getting contingencies for the last few weeks. This is the third time that we're sitting here with the same case.
So that's not exactly correct. We've continued your contempt motions.
Okay.
His motion to vacate was set on this docket, and it had to be to allow him time to serve you so that you had notice of it. So what I did previously, you filed contempt motions. So
Yeah.
I continued those to today's date because
Okay.
this was the date set for his motion to vacate, which needs to be decided first. Okay.
Okay. I mean, he has so right now, what you're hearing, Tanya Quinata, all this freedom, those are all, Tanya is his girlfriend. She's been filling out all his paperwork. She's been doing all.
Hold on, ma'am. Hold on.
Okay.
That's totally irrelevant to whether I find
Okay.
cause for the continuance. So kind of just sticking to the facts of the case.
I mean, we can continue on this for another 2 or 3 weeks,
Okay.
as long as my case is getting brought up too, right? Just as a question, Your Honor.
Yes. So
Yes. Okay.
if we continue his case for 3 weeks, we would what we call track your motions with that, because I need to decide the motion to vacate first before I decide your contempt motions, because your contempt motions are based on his underlying motion to vacate.
No, then I do not agree with it because I need to get back in my house.
Okay. Well, you're not in your house because of a separate and different protection order that isn't related to what's in front of me.
Okay.
You agree with that, correct?
I'm a little bit confused right now, Your Honor, because we had the last 2 weeks, or this is the third week that we were talking about the issues of him hiding money, not letting me in the house, everything else.
Right. So, but hold on. So you're objecting to the continuance because you state you want to get back in the house. And I'm just having you tell me if you understand that the reason you're not in the house has to do with a protection order that is separate and apart from the motions in front of me in family law court. Do you understand that?
I understand that. And the judge had on 9/12 written that I get the house again awarded.
Okay. So I'm just going to focus. I understand there are other cases going on that impact your ability to get into the house. What I'm going to focus on today is whether I believe there's good cause for a continuance of 3 weeks on Mr. Jackson's motion to vacate judgment. What I am going to find is that there is good cause to continue this for a short period of time, which is just 3 weeks, to November 22 at 9 a.m. on this docket. And Mr. Jackson, it is my hope that I know attorneys are scheduled very far out. So it is my hope that you are able to get in with someone who can be present on that docket with you.
Thank you, Your Honor.
The reason I am granting the continuance is that I do understand the last 2 weeks, Mr. Jackson has had medical issues that have likely precluded him from seeking that counsel. I understand that there are unique legal issues that he is arguing regarding his prior counsel, and I am going to give him the opportunity for this first continuance request. This is his first continuance request on the motion to vacate. I am going to grant it. Further continuance requests might be denied or granted depending on the circumstances. And then what I'm going to do, Ms. Jackson, is track, meaning set over your contempt issues and Mr. Jackson's motion to restrict abusive litigation also to November 22 at 9 a.m. Are there any questions from the parties about what I have done today?
No, Your Honor.
I'm just like, right now, he returned the car to me. The car is not safe to drive. I mean, there's a lot of stuff that has been happening in 1 week. Like my dog died suddenly, which I'm assuming it was some kind of a drug. The next day, I see on Facebook 2 of my other dogs are running loose through woodland. I still have no clue if they found back again or not. The strain that it has been taking on me emotionally and physically.
And ma'am, I guess I'm going to say, I understand you've addressed these concerns before. I understand, and I'm just going to go back so that you understand some of those issues are unrelated to this family law case, but more closely related to a separate protection order issue.
But
Okay.
I haven't been in contact with him.
That is not what I'm saying. I'm not saying that you have violated a no contact order. I'm stating that the concerns you're bringing up, some of them do not relate to this family law case, but instead relate to a protection order issue.
Yeah, I understand that it's
Okay.
a protection, so it's a different case.
Correct.
So, yeah, I mean,
Okay.
why are we bringing it into this case?
Because you're bringing it into this case,
Okay.
ma'am. So I'm helping you understand why on this docket, I can't address all of the concerns you're raising. That is my point.
Okay. And I had
Okay.
thought we would do this today since we moved it from last week to this week. So,
Well, we did not move his motion to vacate. That was set for today.
Yeah.
So I'm going to grant a continuance. I'm going to issue a bench order finding good cause to do so through 11/22. Okay.
okay.
So let me ask Mr. Jackson, do you have any questions for me before we see you back on November 22nd at 9 a.m.?
No, ma'am.
Okay. Ms. Jackson, do you have any questions for me before we see you back on November 22nd at 9 a.m.?
I guess not.
Okay. Are you two able to unmute and turn on your cameras?
Can you hear me now?
Yes, I can.
Thank you, Your Honor.
I am here.
Okay. Okay, we're here essentially, according to my notes, on 3 matters, all under the same docket, 233-0024-408. Most predominantly, and the rest of the other motions kind of flow from it, is Mr. Jackson's motion to vacate a prior judgment. When we were here last, we continued this case to today because Mr. Jackson was seeking counsel, or new counsel, I should say. So Mr. Jackson, can you let the court know, and I don't have cameras turned on for either one of you. Can you let the court know where you're at? I don't see notice of representation at this time.
I have not gotten any counsel. Everybody I've talked to will not work in Cowlitz County. So I'm still seeking counsel.
Do you have any appointments set up, or?
No, ma'am. Like I said, everybody I've talked to will not work in Cowlitz County.
Okay. So what is your request of the court today?
Continue.
You're asking for another continuance? Is that correct?
Yes,
Or are you asking to proceed on your motion to vacate today?
let's proceed with the motion to vacate.
Okay. Ms. Jackson, are you ready to proceed on the motion to vacate?
Yes, I am, Your Honor.
Okay. So that is the first issue we're going to take up. I do note that there was the initial motion filed. There was an October 18, 2023 response. filed by Annette Jackson to the motion to vacate. And then I have also received an October 31st declaration from Tanya Quinada. I have received an October 31 declaration from a Christopher Pangilinan, if I'm pronouncing that correctly. I've received and reviewed the October 20th declaration of Mr. Jackson that does also relate to his motion to vacate, as well as response to some of the potential contempt motion that Ms. Jackson has filed. What I don't see is whether that November 20th declaration of Mr. Jackson was filed on Ms. Jackson.
Yes, it was, Your Honor.
So I received in the middle of the night 2 emails. One was at 11:43 p.m. on Monday night, which was the 20th, and one was exactly at midnight on the 21st, so yesterday. I have truly, honestly, no clue which one I'm going by, because the declaration, the writing part is the same, just not the evidence.
I'm sorry, I didn't quite understand the last part you said.
Sorry. The writing is the same of both of those, and just not the evidence. It's 2 different things that I have, the exhibits. So I'm not sure which one he would like to go by, especially beside me, and God served me in the middle of the night. So it was, yesterday morning.
Yeah, so I mean, I guess that's my question. This case has drug on for quite some time.
Yes.
My issue, though, is that Mr. Jackson appears to be filing some additional evidence regarding, I think we can still move forward on the motion to vacate, because I think all of that evidence has been properly served and everyone's had a chance to respond. But it looks like he's making some arguments with regard to your motions for contempt that I'm guessing you want to respond to.
Well, I would like to know which ones he wants to vacate now.
Yeah, so that's not my question. My
Oh,
question
okay.
is whether so you have very recently received this paperwork, which really isn't timely. All documents need to be filed on other parties with sufficient time to respond to a hearing, and typically that's at least 5 days before the hearing. These were filed 2 days ago with the court. You received them, it sounds like, last night. Are you planning to respond to the documents that he has filed on you?
What, you mean by writing or just by now at the hearing?
Either one.
I mean, I can respond to it right now as I'm talking,
Have you had enough time to review his November 20th declaration?
Yes, I did.
Okay. I mean, typically, I would say filing something on someone by email, which also is not sufficient, at midnight is not sufficient. So, Ms. Jackson, if you wanted time to respond and prepare for a hearing on it, you certainly can. It sounds like you want to move forward today. Is that correct?
Well, so, Your Honor, we have been doing this for months now.
Yes,
and they
understood.
will always do stuff in the last minute to drag it out. The whole, when I say they know who they are. And it's just like I get this declaration of Christopher Penguin and of Tanya, and this never got served to me. So, I saw it and I had to drive up to Longview, pull it, it's like they are doing certain things. So that's fraudulent. What they are doing to me is doing everything last minute. So we are pushing this out and out and out. We all know he's not going to get an attorney again. This is, because his other attorney had filed when he quit with an RCA 16 A and B.
So, hold on, Ms. Jackson. I'm just limited question here. Are you asking for more time given the untimely and improper service made on you, or are you asking to just move forward and you're ready to respond?
I'm moving forward. I'm over it.
Okay. All right, Mr. Jackson, we're first going to go to your motion to vacate. As I understand it, in looking at your motion, at the time temporary family law orders were issued in this case, you were represented by an attorney of your choosing. And what you are arguing at this time is that this court should vacate the temporary law orders. You've argued ineffective assistance of counsel, breach of professional ethics, and other duties, primarily, well, all related to what you believe to be actions or non-action by your prior attorney. Is that correct?
That is correct.
Okay, so I'm going to turn it over to you for argument on why you believe this court can and should vacate those temporary orders. Go ahead.
I had no knowledge of two of the cases that went to court. I found out that there was 4 times they went to court. I had no knowledge, and I was not represented, and I was not there. Not sure if the attorney knew about it because he wasn't there either. So I didn't get served any paperwork saying I had court or anything. So that's where I'm standing.
Okay. Ms. Jackson, briefly, I'm going to hear from you just on the motion to vacate. I don't want you to get into the contempt or discovery issues right now.
Yeah.
Go ahead.
He got served each time his attorney got served. He got served. I even reached out by text message, letting him be aware that, hey, there's a hearing. I also asked him at one point, does your attorney still works for you? And he's like, why? So I explained to him why. And I mean, truly, honestly, I have to say, if I have an attorney, I'll reach out on a regular basis and to see where are we standing. And if the attorney doesn't respond, maybe I should get a little bit more aggressive. I don't know. And the motions that he's trying to vacate, they're overridden already. They don't even exist no more from July and August because Judge Evans wrote a new order for September 12th. So there's my 2 cents.
All right, so what I'm going to do is kind of go through a history of this case from early on. This petition for dissolution was filed on June 7, 2023. Ms. Jackson filed a notice of appearance pro se on June 7, 2023. Mr. Jackson had an attorney notice of appearance filed on June 26, 2023 by an Ivan Culbertson, private retained attorney on behalf of Mr. Jackson. A response to the petition for dissolution was filed that same day. Motions for temporary family law orders were actually filed by Mr. Culbertson on behalf of Mr. Jackson. Financial declarations were provided that same day. It was noted for motion docket on July 18, 2023 by Attorney Culbertson. On July 12th, you all were seen on this unrepresented docket. Mr. Culbertson appeared. Because Mr. Culbertson was representing the parties, the case was moved to the represented docket. Then on July 18, 2023, in front of a judicial officer warning, the case was heard. Ms. Jackson was present. Mr. Culbertson, the attorney, was present. Argument was taken regarding the temporary orders. The court made rulings regarding the temporary orders on that date with Mr. Culbertson present. Those orders were signed on July 8, 2023 by the judicial officer. So now kind of what's happened since is Ms. Jackson has asserted that Mr. Jackson has not adhered to the temporary orders, and she filed contempt and show cause matters with proof of mailing to Mr. Culbertson. I'm just looking for his intent to withdraw. So then through this process, on September 12th, well, let me back up. I'm going back to a September 5, 2023. This is a motion that Ms. Jackson filed for contempt with an affidavit of service on Mr. Jackson. A motion hearing was had in front of Judge Evans on September 12, 2023. At that time, Judge Evans took testimony from Ms. Jackson regarding service. The court responded that at the last hearing, they had discussed service issues and Mr. Jackson had been personally served. Ms. Jackson had also served Mr. Jackson via email and mail because of a lack of response from Mr. Culbertson since the time of the temporary orders. The court reviewed the Washington State Bar Association website to verify the address for Mr. Culbertson. The address of service did match. Mr. Jackson was present, or excuse me, Ms. Jackson was present and indicated she had not received any response or correspondence from Mr. Culbertson. The court then issued a ruling that granted Ms. Jackson's request to increase spousal support, provide housing assistance, and other orders within the September 12th motion hearing. At that time, Judge Evans did find that service was acceptable. There also, at that time, well, strike that. Let me back up. On September 25th, 2023, this court received Mr. Culbertson's notice of intent to withdraw. Then we end up here because Ms. Jackson has continued to assert that Mr. Jackson has not complied with the temporary orders. And Mr. Jackson now has raised the ineffective assistance of counsel arguments to the court. My finding is that motions to vacate are appropriate where, for instance, there is an irregularity in the proceedings or some other fault can be found in the process, how these orders happened. That is not the case here. This is a case where Mr. Jackson's remedy lies with any action he has with his attorney. This was a private retained attorney. His ineffective assistance of counsel, and I'm not making that finding, but I'm stating the argument that there was ineffective assistance of counsel is not a grounds for this court to vacate a properly ordered temporary family law order. Similarly, the other grounds regarding any breach of ethics by attorney Culbertson similarly are not grounds to vacate. A client will be held to the orders that their attorney was properly notified about, was present for, or had the opportunity to be present for. So I am at this time denying the motion to vacate.
Thank you, Your Honor.
So let's talk about the other two motions we have in front of us. One is a motion hearing to restrict abusive litigation. And I believe, Ms. Jackson, that's what you have filed.
Yeah.
Okay. And then a motion hearing regarding contempt issues. Here's this, I'm gonna short circuit this a little bit. Just based on the pleadings, I don't find that there's enough for me to make any sort of ruling regarding abusive litigation. I have denied Mr. Jackson's motion to vacate the prior judgments, so I think it's appropriate to move forward on the contempt issues. But
Your Honor?
Hold on a second, but I am not finding, as far as Ms. Jackson's motion to restrict abusive litigation, that there's any merit. Mr. Jackson, go ahead.
I was the one that filed for abusive litigation as well.
Oh, yeah.
Well, I think there's two, well, it's showing up as one, but you both have made that request in your motions.
I
So,
never received anything from her.
well, I was just looking at it. It's in a document. Yours was filed on October 11th. And then her request is, just a minute, I will get there. On October 18th, 2023. Unless I have mistaken, did Ms. Jackson, did you not intend to file your own motion to restrict abusive litigation?
You know what, Your Honor, I really don't know at this point because there's so many paperworks
Yeah.
that I truly honestly, I do not know anymore. I was
Okay.
trying to move with my daughter in, it's been like, paperwork. So I truly honestly do not know at this point if I filed for it, probably because, I mean, all the stuff that they're saying that I have, overdone on paperwork, which
Mhm.
I just think I just filed everything as supposed to.
Okay,
Okay.
so I guess let's make the record clear then. I took your October 18th, 2023 request to be a motion to restrict abusive litigation. Sounds like you're not making that motion to the court, so we can strike that.
Yeah, let's just strike it. I'm just like, yeah.
Okay, and then let's go back to Mr. Jackson's motion to restrict abusive litigation. I do have that motion in front of me. My understanding when I read that motion is essentially kind of the basis appears to be the multiple contempt motions.
Yeah.
That is correct.
Okay, so Mr. Jackson, I'll hear briefly on that matter if you want to add anything to the record.
I want to add something about the earlier judgment is I was not the September 12th hearing. I knew nothing about, had no paperwork on it. And you
But
said I was served.
I'm not going to revisit my ruling on that. You were on September 12th, you were represented still by Mr. Culbertson. He should have appeared on your behalf. So I'm not revisiting my decision on the motion to vacate. I'm hearing now your motion to restrict abusive litigation.
Okay, well, it's contempt after contempt after contempt, and most of it is just flat out lies. I've done, especially the 18th of July order. I followed the rules right there from the beginning.
Mm-hmm.
As soon as I got them. And then the 12th, I knew nothing about until I was sidelined when I was in the hospital.
Mm-hmm.
So we exchanged cars. I have no idea what money I'm supposed to put in the bank because I don't have any money.
Do you have the September 12th order now?
No, I do not. I've been looking for it. I don't have it.
They got personally served to him. They got served to him by, because I had first the sheriff's office in the courthouse. I wanted to have him.
Hold on, I'm just gonna address something that's happening in the Zoom chat. So for non-parties to this case, I'm not taking testimony from non-parties. You're welcome to be here observing. Please do not use the chat to talk about the merits of the case. I see that that is happening for Ms. Quinata. I'm going to delete those messages. They are not part of the court record. Ms. Quinata is not a party to this case. She has filed a declaration, and that will be considered by the court. But the statements made on Zoom will not be considered by the court. Please refrain from doing so. Okay, go ahead, Ms. Jackson.
Wasn't no, he was talking. Wasn't he talking? I'm sorry.
Oh, Mr. Jackson, go ahead.
Yeah.
I apologize.
No, that's fine.
No, I was just saying, I don't have any of those from the 12th of September, or whatever it was. I don't have those papers. I've been looking for them. And
Okay.
I'm not sure what it even looked like.
So Ms. Quinata, it keeps replying to me regarding this case. Please refrain from doing so. Otherwise, I will remove you from the Zoom hearing room. Please do not use the Zoom chat while we're in the middle of a hearing. Okay, Mr. Jackson, please go ahead. I apologize for having to interrupt you again.
So I have none of those. Again, I was sidelined when I was in the hospital about this order that I'm supposed to be following, and then I was in contempt of. I still do not fully know what it entails.
Okay. So you still don't have the September 12th order?
No, I've looked through every paper I've got.
Okay.
Which I have a lot, which doesn't even. I don't know.
Okay. Are you able to come to the Cowlitz County Superior Courthouse and get a copy of that order?
Yes, I will.
Okay. Here's what I'm going to do. On the motion to, hold on, Ms. Jackson, is that you?
Yes.
Okay, go ahead.
So I had when on the 12th, when the orders got down by Judge Evans, I went down to the sheriff's department, filed there for it to get it served to him directly, paid my dues, everything. After 2 weeks, they still have not been filed with him. They had not been served with him. So I withdrew those, and I had somebody serving him that Saturday, which was, I think, if we look in the paper, was on 9/28.
Okay.
At 8:30 in the morning, he was served, and he opened the door, and he got handed by Andrew, and yeah,
Okay.
Brad Shawnsbury. I do not know his name right now, but yeah, he got served, and he was getting the papers, and everything is filed in the records that he got them.
So here's going to be my ruling. First, on the motion to restrict abusive litigation filed by Mr. Jackson, I am going to deny that motion. I don't find that the contempt motions are abusive litigation. But on those contempt motions, I do not believe under the circumstances that I can find that his failure to comply was willful, which would be required for me to find contempt. So I am denying Ms. Jackson's motion for contempt against Mr. Jackson. What I am going to do in this case, because I do understand that Mr. Jackson, number one, believes that his attorney was not giving him documents, and I don't think that's a reason to vacate, but I do think that's a reason to find that his actions in failing to comply were not willful. So I am going to request that Mr. Jackson come to the Cowlitz County Courthouse and ask for a copy, receive a copy of the September 12th, 2023 order. I am going to ask Mr. Jackson, well, not ask, I'm going to let Mr. Jackson know that because I am not vacating those judgments, you will be expected to comply with them moving forward. So please, I understand tomorrow's a holiday. Friday, the courthouse is closed. So please, by next Friday, so sometime next week, come and get a copy of that order. Make sure you understand it and you're in full compliance of it, because if Ms. Jackson were to bring a contempt motion down the road, I wouldn't necessarily be able to find the same finding that I'm making today. So I'm giving you time to receive, review, and comply with the September 12th, 2023 order before I would deem any non-compliance willful. Mr. Jackson, do you understand my ruling?
I understand.
Okay. Do you believe that you could get to the courthouse and receive that order by the end of next week?
Yes, I can.
Okay. Ms. Jackson, do you understand my ruling today?
So, yeah, so he has to pick up the paperwork. So is the ruling of Judge Evans, what's it called in English?
Both Judge Warning and Judge Evans' prior rulings
Yeah.
remain in place. They are not voided. They're not vacated. They are the law of the land in this case. All
Okay.
I'm doing today is saying up through today's date, I am not finding contempt on behalf of Mr. Jackson with regard to your most recent contempt motions. I am giving him time now that I've ruled on his motion to vacate. I'm giving him time to receive the order, review it, and be in compliance.
So he has to, if he picks it up by next week, Friday, from there on out, he has to move out. He has to do all of this stuff that Judge Evans had written down as an order, right?
Well, I want to be careful here, Ms. Jackson. I understand that I assume that there might be a no contact order still in place.
It's still in place, Your Honor.
That would take precedent over this. So no, I think you're mischaracterizing my ruling, Ms. Jackson.
Okay.
So let me be very clear.
Okay.
You still absolutely must abide by a no contact order, and I don't want there to be any confusion about that.
Okay.
That is based on a totally separate cause of action that has nothing to do with a family law case. So a domestic violence no contact order has to be complied with. Failure to comply with that can result in criminal charges. So that is in no way my ruling.
Okay, but so I'm a little bit.
Hold on.
Yeah.
So I'm not gonna dive deeper into the back and forth on whether you think that the no contact order is valid or not. So let me just ask very, very succinctly, do you have any questions about my rulings today that you need clarified? Not about legal advice about the house or anything like that.
Yeah, I mean, I do not understand the no contact order. I don't have contact to him. And
again, I'm not discussing the no contact order. I'm asking if you have questions about my rulings today, which deny the motion to vacate, deny the restrict abusive litigation motion, and deny the contempt issues. Do you have questions about those matters?
Yeah, but it's right now it's like English is my second language. So some of that stuff sometimes just is like really hard on me to understand any of that. So I don't know what to tell you. I'm like really confused right now.
Okay. Mr. Jackson, do you have any questions for me about my rulings today?
No, ma'am.
Okay.
Do I? Well, I do, yes.
Okay.
So after I get this order and I go over it, do I have the ability to contest this order?
So either party always, before finality of a dissolution proceeding, can make motions to modify orders for good cause. So the short answer is yes, but the long answer would be yes, but it depends on the facts that you would present to me.
Okay.
Okay.
Thank you.
Okay, I'm going to go ahead and end the hearings. Thank you both.
So are we having then setting up a next appointment right away or not?
I am not, there's no further issue in front of me.
Uh-huh.
So it would be incumbent upon the parties to renote if they want to bring a new issue to this court.
So the orders that he's picking up, I mean, are they working or not? Are they going to be good or not? I don't, I'm like
Yes.
really confused right now. Like,
So then if
he has to follow the,
Ms. Jackson,
yes,
so I can't give parties legal advice, just like
I
Mr.
understand.
Jackson, you know, I can't throw him a lifeline either. I can't throw you a lifeline.
No, I
I
understand
can
that.
only make a decision based on what's in front of me. So if you are having difficulty understanding proceedings, and I get it, this is it is difficult to navigate legal proceedings without lawyers. Certainly reach out to legal aid clinics or a lawyer if you want further clarification. All I can do is tell you that the temporary family law orders that prior judicial officers in this case have put into place remain in effect. Mr. Jackson is bound by those, absent a motion and ruling to the contrary. At this point, I am not setting a review date because there's nothing else for me to decide unless the parties bring a new motion and note it for docket. Okay?
Okay.
All right. Thank you both, and we will go ahead and end docket.
All right. Thank you.
Thank you.
4 months later.
Okay, number 6 on the docket, 23-3-00244-08, Jackson and Jackson matter.
I'm here. Jackson's here.
Okay. Do I have Elazar Jackson? Okay, be just a minute here. So, let's see. All right, so if I understand correctly, Annette Jackson, you are present, is that correct?
That's correct, Your Honor.
All right, so Ms. Jackson, what I wanted is to set this over to March 26th at 9 to have a response from you regarding the medical.
I haven't gotten nothing from him.
Okay, well, that's an issue. I'll recall this in hopes that he will join, but he should be submitting everything he files with the court, a copy to you.
Yeah, I have not received anything.
Okay. All right. Now, let's see if he joins after a bit. And like I said, I'll recall. Okay.
Okay, so the motion, because with him being in contempt, is not gonna get heard at this point?
I don't even have him here.
Okay,
So that's a real problem.
okay,
And it's a real problem that he's not submitting to you the things that he's filed with the court. So we need to just wait a little longer and
all right, thank you.
all right, sir, what is your name? Okay, I'm gonna have you come up right to this table up here, sir. I already called your case, that's why.
No internet, didn't know which room I was in.
What's that?
I said it's not listed out there where we at.
Okay, I'm not sure why.
Says no internet, so.
All right, so a couple of things that need to happen. First, Mr. Jackson, you need to understand anything you file with the court, a copy of it needs to be provide it to Annette Jackson?
I did provide a copy,
Okay, she's saying she hasn't received anything.
but to the address that's listed on the paper she served me.
Okay. Do you have the item scanned by chance? Scanned into a PDF document by chance?
Do I have it scanned in
Uh-huh,
personally? No.
okay. All right. Ms. Jackson, anything that you've received at all?
No, because he's supposed to email it to me. And I received nothing by email.
Okay. Well, did he mail it to you?
Well, I'm homeless. I don't have an address.
Okay.
So that's why I put the email on it. On the paperwork, the second time even when I had to serve him, that it says to be delivered by email.
Okay, well, there's no court rule that says it must be done by email. Just
Okay.
because you want it by email doesn't mean that it needs to be done by email.
Okay.
Unless there's agreement, and that there's no agreement. So he's filed documents that haven't been scanned, and that's the problem. And at least you can do a general delivery at the post office, at least you used to.
I mean, he sees our daughter on a regular basis. He used to give it to her.
Is there an address for
Yeah.
him to mail that to?
Yeah, she has an address, but he can give it, he sees her personally, so he can give it to her personally and she can give it to me. We had made an agreement prior to send everything by email to me. I mean, he sees our daughter at least once or twice a month.
Mr. Jackson, would that be workable if you provide a copy of the documents to the daughter?
Unfortunately, I don't have my daughter's address. She moved and has not given me an address. I saw her once in the last 3 months.
That's a lie.
Okay, stop. I'm not going to put up with this. So we're going to get this done. I have a whole docket I have to do. So here's what's going to happen. All right, you're going to provide the address to Mr. Jackson of where you want things sent. If that's the address you want things mailed to, you need to also change it with the clerk's office. Okay? And then that will be your official address for where things are mailed to, because sometimes the court mails things too. I understand what you're saying and why you're saying it and the allegations. I've read things. So I need you to make a copy of everything that you have filed with the court. And once you get that address from her where it's to be sent, then I want you to send that to that address.
Yes, ma'am.
Okay? All right. And then I'm going to set this out 2 weeks to have that happen. All right. So get that address to him right away and to the clerk's office right away. And that way things can be sent to that address. Okay. But you have to have an official address.
The clerk, I had changed it a few weeks ago. The clerk at the clerk's counter, I changed the address to my daughter's address. So it is in the court system.
Okay. But then you also need to provide that
Okay.
to him. Okay. Same thing. Everything you file, everything you do with the court, you need to let the other party know. Goes
Okay.
both ways. Okay. So I'm setting your case over 2 weeks. And then that'll also give you an opportunity to respond to the medical matters that were brought up.
Okay.
Okay. All right. So in 2 weeks, that would be, let's see. That would be to April 2nd at 9 a.m. We'll be back here at 9 a.m. Okay.
All right.
I'm not doing anything further today.
All right. Thank you, Your Honor.
Okay. All right.
Thank you.
Okay, I want to call Jackson and Jackson 23-3-00244-08. Okay, this is on for a motion for contempt I had set it over with the idea of getting medical records. That hasn't, other than some basic information, that has not occurred. But the bigger issue is I went back and read your request and clarify, are you asking for jail time?
Yes, I do.
Okay, then you have a right to an attorney. Do you wish to have an attorney?
Yes,
Okay, all right. So with that, we are going to have to locate an attorney that will represent Mr. Jackson on this matter. And how do you say your first name? Elazar?
Elizabeth.
Okay. Mr. Jackson, and that needs to occur before we can go forward on the contempt matter.
Okay.
Okay, so I know you already have an order. I know your issue and concern last week was you're homeless. I understand that. You have an order already that gives you the right to the possession of the house. How you pursue that is up to you. But meanwhile, on the contempt part of this, we will try, court administration will be the ones that locate an attorney for you. I don't know how long it will take. I expect that it's going to take a while. And so in regard to the contempt matter, we are going to set that over to April 23 at this time in hopes that an attorney has been located to represent Mr. Jackson. So Mr. Jackson, what will happen is, if you like, Autumn Terry is the person that will be locating an attorney for you. You're welcome to reach out to her just to check in with her about whether she's located one. Don't expect it to happen real quick though, okay?
Okay.
But is all your contact information current in the court file?
Yes, ma'am.
Okay. So as long as your contact information is current in the file, then nothing will be happening here today until we get an attorney on board for you.
Okay.
Your Honor, one more question. For next week, the 9th, he set an appointment for a motion for a new family law. Are we gonna strike that for right now? Since we have the motion of contempt finished up?
The contempt is a separate matter, and that's the one that has the right to an attorney.
Okay.
In regard to whatever is set in front of me for next week, that's a separate issue, and we'll address that separately. So continue as if that part of it is going forward.
Okay, thank you.
Okay. All right. All right. So with that, there will be nothing more today. And like I said, reach out to court administration, Autumn Terry, if you'd like to find out if an attorney's been located.
I have she has a no contact order, which keeps her from being at my house. And that's why she's not there right now.
Okay, I'm not going to address anything else at this time. I'm not addressing the contempt matter. I'm not addressing anything that you have on for next week. I've addressed the one issue that I wanted to take care of today, which is to tell you you have a right to an attorney and see if you want one. And then attorney will be figured out, and then we'll go from there.
Yeah, because the restraining order says something.
Okay, ma'am. So
the 23rd for the contempt at this point?
correct.
Okay.
That's assuming an attorney is located.
Okay.
Number 5 on the docket, 23-3-00244-08, Jackson and Jackson matter. All right, this is a like scenario. An attorney has just been located and appointed to represent you, Mr. Jackson, in the contempt matter, which is what this matter is on for. He has a right to an attorney, so this matter will not be going forward today. The attorney is just coming on board. And so I'm going to set the matter over to May 7th at 9 a.m.
Yes, yes. So we're doing a scan today with IV contrast.
You need to mute your connection, whoever that is, please. All right, so May 7th at 9 AM, and I intend to go forward at that time.
So you had originally set it for May 23rd, April 23rd, so that's no longer gonna happen.
That was a different case. This matter I'm setting to May 7th.
Okay, and the attorney name is?
You can call court administration. I don't want to make a mistake because there were a couple, 3 different attorneys that were appointed.
Okay.
Okay, all right, call court administration, you get that name.
May I have a question, Your Honor? Because for today's hearing, we had the temporary spousal support modification.
That's what I thought.
I'm not going to address that matter here today. We're going to set everything over to May 7th.
So including the contempt?
Correct.
Okay.
Okay.
Okay. All right, number 6 and 7, Jackson and Jackson matters 23-3-00244-08. It'll be just a moment here. So there are 2 matters that are on for today. One is the contempt matter, and the other is the request by Mr. Jackson for temporary orders. That said, counsel is here just for the contempt matter. And I can hear argument, but I'll tell you, I don't think this matter is ready to proceed to hearing today. I know this matter has been set over for a variety of reasons. So you can hear what I have to say, or I can have you do argument and I'll get to where I'm at. So that's where I'm at this point. So what would you like to do?
Your Honor, on behalf of my client, I appreciate the court's candor, and I will follow the court's directive. If you would like to, if the court would like to address, anything further, I'm happy to hear it. And alternatively, my client is willing to, take a continuance and appropriately hash it out procedurally. I'll defer now to the petitioner what they may have to say to you, Your Honor.
I'm fine with this. The only thing that I would like to say was I got yesterday the paperwork from Mr. Lee, and he wrote in there that petitioner filed an apparently frivolous ethic complaint against Judge Michael Evans, which was included as an exhibit of declaration filed on February 29th, as the basis to disqualify Judge Evans. I never did that.
Okay.
So I just wanted to clear that up before anything else is that this was not on me. I would never go against any judges.
Okay, I wouldn't consider it really anyhow. So again, understanding there are 2 matters, and at this point, the parties have been pro se. And so what I'd like to do at this point, again, with an attorney on board for Mr. Jackson on the contempt matter, the problem the court is having as it relates to the contempt versus the modification is a lack of documentation by Mr. Jackson. A couple of overdrafts is insufficient to show what is actually going into his account. Mr. Jackson also claims medical conditions as a reason, but the fact is he is still working. And again, the information that is provided is insufficient to show anything any differently. As well, it appears the same job has been in place for quite some time. So to essentially reconsider and modify the order of a prior judge is not likely to happen without a great deal more in documentation of both the medical and even more so the financial part of this. It's really primarily the financial part that I'm looking for. The court understands that parties have been representing themselves. So what the court wants to see are 1, copies of the full bank statements for Mr. Jackson for the past 12 months. to copies of the 23 and 22 tax returns. I know there was one in there, but I think it was 2020. And 3 copies of the paychecks for Mr. Jackson for the past 6 months. There's no reason not to provide this documentation under seal and file them with the court within 2 weeks of today's date. I'm setting these matters because there are the 2 matters over to May 28th. Mr. Lee, does that work for you, the 28th?
Yes, it does, Your Honor.
Okay,
Same, I don't have a calendar in front of me, but I assume that's the same docket.
it is.
Thank you, Your Honor.
To make a ruling on the contempt matter, including the non-payment of maintenance and the failure to vacate the residence. And so understand if you fail to provide the documentation, I'm simply going to go forward at that time without anything more. But I want to have a full picture of this before we proceed forward as to what should actually be happening. So do you want me to say again what those documents are? So copies of the full bank statements for Mr. Jackson for the past 12 months. Copies of the 22 and 23 tax returns. And copies of the paychecks for Mr. Jackson for the past 6 months.
Yeah, one question.
Mm-hmm.
When you say the bank statements, that means all of his banks,
Correct. All banking,
all banks.
all banks. And then at that time, the court will look at the motion for contempt and the motion for modification. And again, I'm saying this in part because they've been representing themselves pro se.
Very well. Thank you, Your Honor.
Thank you.
Appreciate it.
All right, Jackson and Jackson matter. Cause number 23-3-00244-08. It'll be just a moment. All right, the court had directed the turning over of documents. That has been done from what I can see. This really wasn't a discovery issue as much as the documentation of what I was looking at as far as the contempt matter and the motion for temporary orders. So the motion for temporary orders was by the respondent. I've reviewed that, and so Mr. Jackson, anything further on that request?
Just that we requested, that we have mediation and she refused.
Okay. So turn off your camera and back. You're not to record these proceedings. Shut it off.
I'm not recording.
Then get rid of the camera.
I'm not.
Get rid of the camera. Ma'am, bring it up.
Sorry.
Bring it up. And get it back when we're done. No. All right, so going back to the temporary orders, ma'am, anything you wanted to say in regard to the temporary orders?
No, not at this point, no.
Okay.
I'll worry about the content.
Okay, so in regard to the temporary orders, This matter has been before the court twice on temporary orders already. The issues that have been requested for a third time have already been ruled on by the court. So the court is not going to be doing another ruling that changes what prior courts and judges have ruled on that. This is the court understands respondent may not like how the court had ruled in September 23, but the court finds these orders stand. There is no showing of change in circumstances that has been shown or verified by the respondent. As well, the request for the restraining order is denied. So in regard to the temporary orders, that is denied. That brings us to the request motion for contempt. And so this is your motion in regard to the motion for contempt. Anything you wanted to add on that?
Well, he finally had ended all the, gave me all the paperwork that has been requested by you and also by me. We are missing a few months of statements for our joint account on our service public credit union. And he also filed joint taxes on us for 2023. And I was trying to file taxes and I got my taxes denied because he had filed them already with my social security number. So, yeah, I mean, what I do want is I want my house back by the end of the week. And I want to get him started on the spouse support that he passed paying me. I haven't received anything since February, so that gets him at this point of over $22,000 on back support. I've been sleeping still on couches. The car broke down. I had to borrow from my kids another one. I'm like at my end's with. I had emergency surgery 2.5 weeks ago. So yeah, I just want finally getting all the stuff that was ordered in the judgment on 9/12 to be done, which means he needs to move himself out of the residency and start paying me my spousal support.
Counsel?
Yes, thank you, Your Honor. There's no doubt, obviously, that this is a contentious proceeding. Nonetheless, this is the petitioner's motion for contempt, and asking to put a man in jail over financial noncompliance is a pretty steep slope. It appeared that your court found that the documents were produced responsively. I submitted an affirmation as well, just outlining the basic facts of which documents I saw were produced by my client. In short, my client comes nowhere near the standard that he should be held in contempt. Regarding the petitioner's other things, again, I'm not the family law attorney here, but if she is upset with some of those things, the items, in short, that's the trial realm. And we're arguing very narrow here whether my client should go to jail. And that's a high bar. And under the case law in my briefing, which I won't, provide the court further, my client should not be in jail. He has complied in a good faith compliance here. And if there are other issues, are basically our family law court rules and are the remedy, and she can motion appropriately. But at this time, again, my client should not be put in jail, Your Honor. Thank you.
I will waive the contempt of him going to jail if he is willing to finally move out of the house as ordered on September 12th. Is he finally starting paying spousal support? I will waive the contempt. I will waive the whole jail time, but stuff needs to get done. I need to get off the couch.
So I've reviewed the files and record. I went back and I looked at the prior orders, and based on those files and record, the court finds the following in regard to contempt. Court does find the respondent in contempt of failure to pay maintenance as ordered and was so done in a willful and intentional manner. The court grants a judgment in favor of the petitioner for $1,600 per month from July 1, 23 through August 31, 20. That would be 23 as ordered on July 18, 23. And $3,000 per month from August 1, 23 to March 1, 24 as ordered on September 12, 2023. This respondent can purge the contempt by immediately resuming the payment of maintenance as ordered, plus $300 per month toward the judgment of the total back due amount. The judgment shall carry interest of 12% interest. The court is not considering putting you in jail at this time, but you need to understand that you need to come in compliance with not only one, but 2 court orders that have been made in this case that you have completely failed to follow. In regard to the moving from the house, you are to remove from the house by June 21, 24, which is substantially past the due date that you were ordered to exit the home back on September of 2023. You have failed to do this. If you have failed to do this, then the court will consider a contempt motion and possible jail time. You have totally ignored the orders of this court, and I expect you to comply with the orders as previously ordered. And what I did see by the financials is that you had substantial sums. Rather than pay the petitioner as ordered, that money seemed to have just disappeared. I have no idea where. I don't know anything about that, but you certainly had the means in which you could have paid her the maintenance as ordered. The party will be set on the universal trial assignment docket for June 12, 24, where the case will be set for a 1-day trial to get this case done. Coming back and back and back is not the way to resolve a case. If she doesn't want to do mediation, that's her choice. This matter is going to be set again on June 12, 2024 for getting this matter set for trial. This case needs to move forward and get done. You'll need to prepare orders that reflect my ruling. So we'll go ahead and do a presentation on, let's go ahead and do June 11 at 9 a.m. And you'll need to get your proposed order to Mr. Lee so that he can see that it reflects my ruling.
If I may, Your Honor.
Go ahead.
And Ms. Jackson, technically I'm addressing the court, but also to you. I'm more than happy to facilitate based off of the fact that I have access to the court records and minutes. I'm more than happy to assist drafting that order to reflect in the interest of making sure that it's a smooth presentation on the 11th. So please, you have my contact information, but bear that in mind.
So let me just explain.
Yes, sir.
You can contact Mr. Lee. It sounds like he'll draft the order.
Okay.
And that way you can look at what he's put together. Obviously, as an attorney, he has the knowledge to do that. Appreciate that, Mr. Lee. And then on June 11, it'll be presented to reflect again what it is that I've ruled. Okay, that's what it's about.
And just a brief procedural matter, Your Honor, after the presentation order, are you satisfied if I just submitted ex parte a motion to withdraw given the
That's
contempt?
fine.
Thank you.
Thank you.
Your Honor, I have just one question. So is on the June 12th, we're gonna have the trial?
No, that's to get a date for the trial.
Oh, okay, all right, thank you.
Yeah, and that's okay. So I have a few different dates here. So June 11 at 9 a.m. for the presentation of the order. June 12 at 9 a.m., that's via Zoom, it's not in person, is to set the trial for a 1-day trial. Is she now on that docket? Is she on that docket now? Can you put her on that docket? June 12th? Yes. Okay, thank you. And then the date by which Mr. Jackson is to exit the house is June 21, 24.
Thank you. Would you just for my notes as well, just repeat the amounts from your prior orders that Mr. Jackson owes?
So in regard to $1,600 per month from July 1, 23 through August 31, 23. As ordered on July 18, 23. And $3,000 per month from August 1, 2023. So that doesn't make sense. You'd have to go back and look at the order of September 12. I'm not sure when the 3,000 began. I think it's 9/1.
9/1, yeah.
Yeah, so 9/1. 9/1/23 to March 1, 24. And ma'am, so you understand, I stopped the judgment amount at the time that you filed your motion because that sets the amount requested.
Yes. No,
So if he continues to not pay, it would start from that time forward.
Okay.
Okay, just so you understand why the judgment isn't till today's
Okay,
date.
yeah, no, that's fine.
And then $300, the $3,000 per month plus $300 per month toward the judgment. So 3,000 regular, 300 per month toward the judgment, 12% interest.
Thank you, Your Honor.
Next, I have Annette Jackson and Eliezer Jackson, 23-3-24408. I'll ask if Mr. Okay, great. Go ahead and take a seat if you'd like. You're Miss Jackson and you're Mr. Eliezer Jackson?
Yes.
Okay, very good. I believe there was a notice of disqualification filed, and I'll just pull that up just to confirm that. Okay, it looks like that was filed on 23rd of February, so I won't be able to hear the matter today since that's been filed. So we'll take a look at some other dates for that presentation of the order. Two options. One would be June 21st or on June 28th. Those are both Friday mornings, 8:45. Either of you have a preference?
June 24th would work for me.
21st on a Friday.
Yes.
Okay. For you, Mr. Jackson?
Yes, okay.
That'd work okay. All right. So we'll set it over to June 21st. Let me just confirm that's the correct date. June 21st it is at 8:45, and we'll see everybody then.
Okay.
Thank you.
Thank you. All right, then I have number 8 on the docket, 23-3-00-24408. I have Annette Jackson and Eliezer Jackson. Do either of you have an attorney present at this time? Mr. Jackson, you need to unmute.
No, I don't have anything.
Okay, Ms. Jackson, are you able to unmute?
Yes, I am.
Okay, so I'm showing that we're gonna set this for trial. Is that what the parties are requesting?
That's what Judge Hahn is requesting, yes.
Okay, and how much trial time will you need?
She said 1 day.
1 day? Okay. And this will just be a bench trial. No one has requested a jury, correct?
That's correct.
Mr. Jackson, does 1 day sound sufficient for you?
Yes.
Okay. So Ms. Anderson, I guess we'll start looking for a 1 day family law trial.
How about the week of July 29th?
Works for me.
Mr. Jackson, will that work?
July 29th?
It'll be the week of July 29th. We won't know the exact date until you come to readiness, which will get you that date in a second. So are you open pretty much every day the week of July 29?
Yes.
Okay.
And then readiness will be July 23rd at 11:30.
And then I'm going to give you one more date. No. Yeah. Okay, hold on, folks. We're going to get you a pre-trial date. Yeah. Oh, it'll have to be, okay. Okay. Let's do, we're gonna do July 16 will be your pro se pre-trial date. What time is that at? Is that 1 o'clock? 9 a.m. Okay. We're going to do July 16th at 9 a.m. It might, when you go to log into that, it is going to say represented docket. We have to do that because of the disqualification of a judge that was filed. So it won't be your normal pro se, meaning self-represented family law docket. It will have to be on the 9 a.m. represented family law docket on July.
So it is a Zoom?
It is on Zoom. All the pre-trial and the readiness are Zoom only. Yes.
Okay.
Okay.
All right. Great. Thank you.
All right. Anything else you folks need?
No, I'll be good.
Okay. Thank you both.
Thank you.
All right, so that brings me to the Jackson and Jackson matter. I see Miss Jackson is present, but I do not see, oh, there's Mr. Roberts there. Shoot. All right, Miss Jackson, my concern is that we don't have either Mr. Jackson or Mr. Lee here. And so I don't know exactly what they were told. So that concerns me that counsel is not present.
The counsel wasn't present last week either, and I have tried to get a hold of him, and he's not responding. I did not get any orders from him. I had sent some orders back to you that I had written out myself after he didn't contacted me. And Mr. Jackson knew that it's court date today at 8:45.
Okay. So I think what I will do, because anytime I know Mr. Lee is very good about appearing for dockets, so I'm concerned with him not here. And I did receive your proposed order, and for the most part, I think it's okay, but I did not order jail time. I said another contempt could be brought requesting jail time if he didn't do it. So.
Well, at this point, he hasn't done any of the things that you had asked him to do.
Okay, well, I get that, but at the same time, I was looking for a new contempt. So I think what I will do is go ahead and put this on July 2nd, and that way you can just be here in the courtroom at 9 a.m.
Okay.
And then that way, if you could just reach out to Mr. Lee and let him know it got set to July 2nd at 9 a.m. for presentation.
Okay.
Okay. All right, and we'll take care of it then.
One question, since he's supposed to be moved out by today, I just have to wait now till the 2nd.
Well, I can't provide you with legal advice. Right now it's only on for presentation, and then you'll need to take the steps if he fails to move out and follow the order. Take the steps as you know you've done in the past. So
Okay.
I'll just leave it at that.
Okay.
Okay. All right.
Yeah.
All right. Thank you.
Thank you.
All right, so going to number 6 on the docket, 23-3-00244-08 Jackson and Jackson matter.
Good morning, Your Honor. Tom Lee here for the respondent.
And Ms. Jackson is present here in the courtroom.
Yes.
All right, so Mr. Lee, I just received your proposed order. And I don't know if Ms. Jackson has received a copy of that.
No.
Okay.
Your Honor, just administrative goof on that. I just while we're on this docket, for the record, I realized when I sent it to court administration, I did not include Ms. Jackson because her email didn't auto-populate, but in short, I made sure to correct that. Now I understand she hasn't had time to review it, but this order is just a reflection of what occurred at the May 28th hearing and oral ruling by the court, as well as seconded by the clerk's minutes.
So here's my concern is, on one hand, Mr. Lee's order lists things, but it doesn't include things like the judgment. Did you see Ms. Jackson's proposed order?
I didn't, Your Honor.
Okay. So it's on the contempt, and it has so that's a problem. That both of you need to exchange what it is, but I'm more inclined to use Ms. Jackson's order because it has the judgments, it has the summary, it's a contempt order, which is what is necessary on the contempt matter. You can always add the other things in. So that's the only issue that I have in regard to Ms. Jackson's is I did not specifically order jail time. What I said is that you need to note it up again and put it back on a docket again. And I just wanted it understood by Mr. Jackson that if this continues, that the court is willing to consider and put him in jail if that's what it takes to get him to follow court orders.
Understandable, Your Honor. I would be satisfied then if the court just wanted to amend Ms. Jackson's proposed order, sans, of course, the jail time clause. That would be fine with me, Your Honor. I understand, it's a busy docket.
White out, mine doesn't seem to be here.
May I ask a question?
Go ahead.
What does this mean now?
So I can only give you so much information, but I'm taking, I'm whiting out under paragraph, I don't know if you have a copy of your order.
Yes.
If you look under paragraph 10, jail time, I'm whiting out where you had included that he had 30 days of jail time and marking does not apply.
Okay.
And then also under going down further under paragraph 10, it says respondent begins making payments immediately on the current spousal support as well as the $300 payment per month on arrearages and the total amount of $3,300 each month payable by the first of each month, that the respondent and his 5 roommates have vacated the family home located in Woodland no later than June 21, 24. Last, the conditions listed in paragraph 13 must have been fulfilled by the time the review hearing takes place on June 25, 24, 4 days after the last day that the respondent must have vacated the home. I'm taking out this whole line about jail time again. And if he has not vacated, let's see. All right, so I think the rest of it is about the vacating. Let me just double check that there isn't anything else. I think that removes all the jail time language. Okay, I think I got all of the jail time. All right, so with that, I'll sign off on the order. Mr. Lee, are you okay to put approved via Zoom?
I am, Your Honor.
All right, so what does that mean? It means that I've signed off on your order, but I have not ordered the jail time. It is up to you as to whether or not you pursue it further or what you do. I'll leave it to you. If you want to consult with an attorney or whatever you would like to do, that's up to you.
I had also filed last week at the Clark County Court for a protection order, and it got approved, but it has for some reason not been sent over to the Cowlitz County office in Woodland. Where it says again, he needs to vacate the house, everything else.
That's a Clark County matter. That's not something
Okay.
I can assist you with at all.
Okay, so what is with the moving out? Is this now? You had mentioned, on the 21st, he still has not moved out. Nothing has happened. It even got worse.
I would ask you to talk to an attorney. There's Cowlitz Wacayacum Legal Aid. There's Northwest Justice Project. You can maybe contact one of them and find out what your rights are and what you can do. I can't give you legal advice.
So is this whole order getting put to another date again?
No, I've signed your order.
Okay.
It just found him in contempt, so you have another contempt order.
Okay. All right, Mr. Lee, is there any possibilities that you could answer any of my phone calls?
Well, I can't really provide, Ms. Jackson, I will give you a call. I want to be respectful of the court's time, and the court has been very patient with us on this matter. I will call you. Just keep in mind, I can't give you legal advice because I'm appointed to represent the respondent in this matter.
And I understand, Ms. Lee, it was just I had called you several times about the order that you had proposed you would be writing, and nothing had happened. I left you in the last time I saw Mr.
We're done on here.
Yeah.
Okay.
Thank you, Your Honor.
Going to take number 7 on the docket, 23-3-00244-08 Jackson and Jackson. All right, do we have Mr. Jackson online?
Yes.
Okay, so this is pre-trial, which is, I will just be giving you kind of a rundown of some basic things that you need to do prior to trial. First off, you'll have a readiness that is coming up, a date, I don't know, let's see, like 23rd. What time are those at?
11.
At 11:30. So you have a readiness coming up for a purpose of finding out what exact date and time your trial is going to be set. Meanwhile, you need to be prepared for trial. So if you go to, I'm going to give you the website if you don't know what it is. It's Cowlitz Superior Court. So COWLITZERIORCOURT.US. That's our court website. If you go to the court website and then go to the self-help page, on that page, you're going to see a couple of things that would be of help for you. One is an article for self-represented litigants, which is 10 steps for presenting evidence in court. So that's one thing you want to read and be familiar with. But meanwhile, the item that's going to give you more information as far as trial readiness is a family law trial readiness checklist for pro se, meaning self-represented. So family law trial readiness checklist for pro se, meaning self-represented. And it's a list of suggestions as to what may apply to your case. Every case is different, so not everything applies. And you'll be able to click on things that will tell you that, or get you to the forms that you need to use. So if you just look at that list of items that you will probably want to have available to you. Now, understand, if you are going to use something at trial, let's say it's a deed to the house, make sure that a copy of that is provided to the other side, as well as that there is let me back up for a minute. There's a copy that you'll use for purposes of evidence, and then you need a copy for you, a copy for the other party, and a copy for the judge.
Okay.
Okay, so make sure that you have the copies of everything. And so when you go through this list, just keep that in mind. Okay.
Yes.
All right. So that's just a real broad overview of what you need to have for time of trial. Prepare any questions that you may have for the other party. If you are going to call witnesses, you should have a witness list. And that witness list should also be provided to the other party so they know who you're going to call as a witness.
Okay.
Okay. So I can't think of anything else at this time, but read that article. That's going to help you as far as presenting evidence. And then read that readiness checklist, so you know which documents you need to have, and some suggestions as far as items you should be prepared with.
So do you have by next week for the readiness? All of those?
No, this is for the time of trial.
Okay.
So readiness is strictly about getting your date and time of your trial.
Okay.
All right, are there any questions? Mr. Jackson, any questions?
No.
Miss Jackson, any questions?
I just have a question, if it would be to close the trial or to put him in contempt again.
That you'll need to seek legal
Okay.
help. Okay,
Okay.
all right. So, you know, you can always go online. There are other things online that are self-help for a pro se dissolution trial. So you can always try that too. So not everything is on our website, but just some things that can help you.
Okay.
Okay,
Okay.
all right. That's it for today.
Thank you.
The trial began on August 2nd and was continued for a second day of testimony with Judge Evans, who's the one that signed the final decree. We can also see that he put some judgments on the record. While we don't get a lot of information from Odyssey about their division of property, we do learn some interesting facts about these judgments and what was awarded to Mrs. Jackson. She was awarded half of the joint tax refund he got when he unilaterally filed the return without telling her, and she was awarded a refund of the cost of the tax preparation fee. She was also awarded over $31,000 in spousal maintenance arrears, as well as an additional $2,000 for additional costs, according to the file. And finally, she was also awarded the house in the divorce. I assume he ended up losing out on the house due to the need to compensate his wife for the thousands upon thousands of dollars in marital funds that he squandered and hid during the divorce. But their trial was not the end of this case. No, in fact, it's only going to get crazier. Mr. Jackson immediately filed a motion to vacate the final decree, which was denied without a hearing. 6 months later, in March of 2025, Mrs. Jackson filed another motion for contempt that appears to have alleged that Mr. Jackson has still not done the things that he was ordered to do in their final decree. At the hearing, not only did the commissioner find Mr. Jackson was still in contempt, but it also seems that Mr. Jackson was a no-show because she issued a bench warrant for him. The commissioner also issued new judgments against Mr. Jackson for this contempt, including $57,000 for items she was awarded in the decree that he never gave her. I'm assuming it's stuff he sold or disposed of, which is why there's a money judgment instead of an order to return it. There was also a new judgment for spousal support arrears that brings a total to over $21,000, and he was also assessed a civil penalty of $250. Finally, she was also awarded $17,000 in mortgage back payments for the house. I can only speculate as to why she was awarded this. My guess is that it's to compensate her for the last 6 months, because she's been barred access to the house because either Mr. Jackson or his girlfriend have been living there, but she's the one who's been required to pay the mortgage since the divorce. In April, it appears that Mr. Jackson filed motions trying to have the bench warrant quashed, his spousal support payments reduced, and he's made some sort of motion to try and make her desist in filing motions for contempt. They had a hearing for those motions in May, which did not go the way Mr. Jackson hoped, and in the end his bench warrant remained active, so it doesn't sound like he turned himself in or did what he was supposed to in order to purge the contempt. Now, I don't know if Mr. Jackson is still living in the house at this point in the case, but I can tell you for sure that I know Mrs. Jackson isn't. I know this because she sues her ex-husband's girlfriend for damages and to eject her from the premises, and she does this at the same time she's motioning the court for contempt. She's going after both of them over the house. I don't know if she had a lawyer for the new family law hearings, but I'm pleased to see she has one in the civil suit hearings. So make sure you join me for part 2, when we'll have 3 of the hearings from the civil action, with Mrs. Jackson motioning the court for a writ of ejectment and damages against the felon squatter girlfriend, and the girlfriend trying to claim a fraudulent lease and other crazy stuff. We'll also finish up with an update to the Jackson divorce case, including more judgments from the court and a shocking final update about Mr. Jackson. You don't want to miss it.